Morning, good morning, good morning. It's Tuesday. It's October 14th. The week is going to be all messed up because we streamed yesterday on a Monday and we had that wild sentencing in the Donna Adelson case. And though today we are not talking Donna Adelson, we are still talking one of our former trials because we just covered the Cardi B trial. For those of you that watched the Cardi B trial in any way, just put a 1 in the chat. For those of you that didn't, don't worry. You don't need a deep knowledge of the trial. We will do a road so far because today we are taking a look at the attorney sanctions that at one point I was just rooting for. And well, when I went to pull all the documents, those of you in the Law Nerd Lounge know I was up a little bit late. That's not unusual for me, but I was pulling documents because there is a sanction hearing set for Friday this week, October 17th, in the post-trial litigation of the Cardi B case. And that is with regard to the things that went down during trial with plaintiff's counsel. And so to get through the voluminous motions today, because one of them is 69 pages long, and it's full of sidebar transcripts. I made a second cup of coffee. I did. 69 pages with sidebar transcripts. And then, as I was pulling the rest of the documents, we have a response from the plaintiff's attorney. And I saw the first sentence, and in my office by myself, sometime after 11 p.m. last night, literally said, "No, you have to wait for stream." I read the first line and went, no, put it in the folder, wait for stream. So it's going to be like that. But the only way we're going to get a full feel for the plaintiff's attorney is to take a look back at a time oh so long ago in 2023 when this same attorney seems to have caused a mistrial by getting into a physical altercation with other attorneys. Yes, a mistrial because they got into a fight during trial. So we are going to go over that first because we need the background of this attorney. But for those of you that watched the Cardi B case, this attorney seemed to just say, "I know you are, but what am I?" And so every time Cardi B's lawyers would say, "Your Honor, that's in violation of the motions in limine," plaintiff's lawyer would say, "But Your Honor, they did it. Nuh-uh, Your Honor, they did it." The fact that counsel never actually said, "I'm rubber and you're glue," is wild to me. Because he was like, "Nuh-uh, but them. Nuh-uh, but them. Your Honor, it's what they did to me." So if we want to talk about the motions in limine, the lemonade, we're going to talk about it because some of you were really appalled by plaintiff's questions. I was with you. Sometimes I think I give a little bit more grace to lawyers because I'm like, they're doing their job. And then I hit a point where I'm just like, fuck this shit. What are we doing? Because there is a level of professionalism, and I will probably say this multiple times today. Lawyers do have a duty of zealous advocacy, but that does not overshadow their duty of candor to the court. First and foremost, lawyers owe a duty of candor to the court. And when you are in law school, they try to bring like the fear of wrath into you about the things you're going to get disbarred for. And then if you look at some of the stories we've covered, particularly in California, where I am still a member of the bar, you go, how do these people still have their license? And then if you've been with me through the Girardi stuff, those are questions that are still being asked. How in the world do some of these people still have their licenses? Honestly, I think the licensing agencies really should be harsher. If you're there to protect the public from lawyers that are wilding out, I think you should be more strict. And I don't think you should be more strict on a lawyer whose, I don't know, lawyer trust account accidentally accrued interest because of the bank. And then they're like, your accounting's off. That's not the problem. That's not the problem. But getting into a physical altercation in a hallway and causing a mistrial, that's a problem. And I wish I could say I would never see this. I could never see this happen. But I've seen lawyers threatened by other lawyers in court. It's wild to see. And maybe we'll get into some of those lawyer things. I also don't just think it's lawyer licensing agencies that should be more strict. I also think that medical licensing agencies are a bit too lenient. I do. I think they could be stricter. I do. Look, zealous advocacy comes with a weighty responsibility. You are charging people a lot of money to protect their rights. And if you fuck that up, people can lose their rights because of what you're doing. It is not a job that should be taken lightly. And it's okay if law is not the job for everybody. It's an opt-in thing. A, law school's fuck expensive. B, the bar exam, I mean, I don't know why they're making it easier, but the bar exam is supposed to be challenging. It is okay to weed out those that aren't great in the profession. And I think law is a profession that is on the precipice of needing a whole lot of conversations around what this profession looks like and what this profession looks like in the day and age of ChatGPT and other AI. And we're going to talk about that too, but not today. Because good lawyers are tainted by those that aren't. But I'm not really worried about the lawyers. They'll be fine. It's the public that doesn't know, because how do you know? How do you know? You hire a lawyer, they sound great in the office, they tell you everything you want to hear like a really, really slick car salesman, and you're just like, I love it, I love it, I love it. And then they get into court and you're like, who the fuck is this person? But how would you ever know? And so there's a responsibility to protect the public who can't necessarily know. It's why I say one of the best ways to find an attorney is by direct referral. If you know a lawyer, ask them. There's a lawyer we know on the internet. There's many of them. Ask them, do you have a referral for this? And oftentimes they will say, I have been up against this attorney. I can refer you to them because I've seen how they work. But even then, a lot of you in the chat are bringing up Murdaugh and Girardi. Even then, Girardi's clients, the ones that he was great with, were like, he's great, and kept recommending him. How are you supposed to know that this lawyer might walk off with your settlement when he's on the front page of everything and having dinner with the governor? I mean, how is anyone to know? So I think that it is the job to really protect the public when you're looking at these attorneys. So we're going to talk about it today. We're going to take a look at the sanction motions. Sometimes I wave sanction motions off. It's like, okay, civil attorneys asking for sanctions and then billing their clients for the sanction motions. Florals for spring. Riveting. Like, it just is. But this goes beyond that. And so we are going to talk about it because also sidebars, there are sidebars. So let me know where you're coming in from, what you're drinking. I've got coffee, round 2. We're going to roll the intro. We're going to get into a lot of documents today. And we're going to figure out what the tea is because I really want to see what's in the transcripts. I really do. It was hard to not just sit down and read them till 1 a.m. But I distracted myself playing mobile games. We'll talk about that in a bit. Let's roll the intro. For live court coverage. Yeah, that sounded weird. It was me. The law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. That was me. That was 100% me. Emily, what are we doing? Some days Some days it just goes well, and some days not as smooth, but still moderately well. So for those of you that didn't watch the Cardi B trial, no worries. We're just talking about plaintiff's counsel. Now, during the Cardi B trial, there were lots of objections, and there were allegations of violations of motions in limine. There were objections during closing argument. There were so many things. And so briefly, I was like, who is this attorney? How long has he been a member of the bar? Like, how do you not know this? Like, literally the entire trial, I was losing my mind and like, what are we doing? And so I Googled real quickly and found a mistrial caused by an altercation in the hallway. And I'm trying to see which of these articles is first. And I was like, what? And so we covered it briefly, and I'm like, okay, chat, we can't derail with the ADHD and rabbit hole into this today. We will come back. And then all the Corey Richins stuff popped up, and we hadn't had a chance to come back yet. So today we are getting back into it and then taking a look at this sanctions motion because it's absolutely necessary. I'm going to make sure that I have chat up in both places so I can see it more easily because I did and then I didn't and now we're here. So also, I just had to change my chat again from top chat to live chat. Don't forget to change it from top chat to live chat so you see all of the law nerds chatting because, well, it's nice to not miss anything in the conversation. So we're going to take a look at two. Law Nerd PHL said, on a plane using Delta Wi-Fi for this, couldn't wait for replay. I love it. You know that Delta is my carrier of choice. And I am optimistic that one of these days on the little YouTube space on Delta that we will be there too. And you can just rewatch a trial with me. Delta might be like, maybe too many fuck words for us. Also, y'all, I have to say, I was annoyed and offended by this attorney before he started going after Cardi B for cursing. I was mad before that. I was that was literally the sprinkles for me. I was pre-annoyed. My coffee's going to get cold while I'm talking. So when he was like, who uses language like that in a courtroom? After he had said, say what you said to her, say what you said to her, say what you said. And then he was like, who uses that language in court after he made her I was so mad, but I was annoyed before that. His questions were rude and offensive. And there were times lawyers ask rude questions and it's like, yeah, it's kind of necessary for their job. There were things that were so unnecessary. So unnecessary. Cal in the chat said, interrupted her to tell her to say it again. Yeah, and to be like, say it to her face. Say it to her face. Oh. So, this attorney was in trial in Los Angeles. So instead of swooping, I think we do need to fly to LA. I mean, we're going to try to avoid the storm. I heard that there were some tornado warnings in Los Angeles. Like, look, part of the thing when you live in LA is you're like, look, I know we might have fires and earthquakes and riots and whatever, but the Lakers are going to win. And the food is good. The weather is great. What you never sign up for is freaking tornadoes. So don't float away and let's fly to Los Angeles. Maybe we can take, LAX has the fancy thing, doesn't it? The fancy where you like get like driven from your car to the private, like non-LAX space. Let's just pretend we're doing that. We're going to just do the fancy like private airport situation before we talk about this lawyer. What's the driving one where the housewives do it when you go to LAX and you go to the private thing and then they drive you and you walk up the stairs, whatever. That's what EDB Air is doing. We're all just flying like quasi commercial. It's perfect. So let's take a look at this article real quick. I'm going to make sure. Oh, let's try it. That looks better. This is coming to us from Law 360. The headline is Geragos. For all of you that think I'm saying the Pokemon, I'm not. We are talking about defense attorney Mark Geragos or Geragos, their firm, etc. Geragos mistrial linked to alleged attorney hallway altercation. This is story number 1. We're going to go to story number 2 in a minute. A California state judge declared a mistrial Monday. This is from July 10th, 2023. Declared a mistrial Monday in a contentious legal malpractice case over allegations that Geragos and Geragos botched a medical malpractice suit. Did it end up on the TV show? Like, do we also have a Dubrow involved? How many names? How many games? How many names? An outcome that a Geragos attorney attributed to a purported physical altercation between lawyers in the hallway outside court last week. I will say, getting a civil case to trial is so difficult and expensive and time consuming. To have a civil case be in trial, to then have a mistrial due to the attorney behavior is wild. Ad Komet in the chat said, I named my shiny Gyarados Mark. Red with rage. Speaking of red, it wasn't immediately clear in open court why Los Angeles Superior Court Judge Mel Red Recana. Hey, Red. I want to hear the backstory of this so badly. But I am going to refrain until I am done with all of this and then reach out to the people I know in LA and be like, did anyone know about this? It wasn't immediately clear in open court why LA Superior Court Judge Mel Red Recana declared a mistrial in the case, as he didn't explain his reasons ahead of the decision. But Geragos and Geragos attorney Alexandria Kazarian told Law 360 that the mistrial involved a purported physical altercation allegedly initiated by the plaintiff's attorney against a defense attorney in the hallway outside the courtroom at the end of the day Friday, which some jurors may have observed. Kazarian, who wasn't in court Friday afternoon, said she did not observe the alleged altercation, but she was present on Monday for closed-door discussions between the judge and the attorneys that concluded with the mistrial declaration. Which Judge Recana was in the ASAP Rocky trial? Was it Mel Red Recana or was it Julian Recana? There are 2 Judge Recanas. They are related, but there are 2. Because wasn't ASAP Rocky a criminal case? And this Judge Recana is this Judge Recana is in civil. I think the other Judge Recana is in criminal. They are fought. Red Recana is dad. Julian Recana is son. So if Rocky was criminal, it was son Recana, not senior Recana in civil. But I didn't know that. I will take a look. Okay, let us continue. Because I thought the ASAP Rocky case wasn't that Judge Arnold? No? I thought ASAP Rocky was Judge Arnold. Maybe not. I might be confused. Either way. This is not a criminal court. What you don't expect is for the attorneys to be brawling in the courtroom. It was Judge Arnold? Yeah, I thought it was Judge Mark Arnold. Because he was hollering at John Lewin and the other attorney. Anyway, continue on. The judge is different here. The attorney, the plaintiff's attorney, is the same plaintiff's attorney as the Cardi B case. That's why we're getting there. All right. Continuing on. The attorney who was in the closed-door discussion after the Friday altercation told Law 360 that the trial was an abomination, and it appears that this was calculated and engineered by the plaintiff's side for the purposes of getting a mistrial. That is a huge allegation. The allegation is this trial's bullshit. They were going to lose, So they suspect and allege that the plaintiff's attorney, same plaintiff's attorney in the Cardi B case, calculated this to cause a mistrial. That is the allegation. It goes on to say the daily disrespect by plaintiff's side directed at witnesses, experts, counsel, and the system as a whole, including the jurors, was mind-boggling. Gee, where have we seen that from the same attorney? The plaintiff's attorney, Rosen, Janfaza, who I know a lot of people know by Rosen. We will shorten it to Ron at this point. No note. Car is gone. Someone needs to send this Ron a freaking howler into court. Sanctions! Plaintiff's attorney Rosen denied Kazarian's characterization of a physical altercation and rejected her quoted statement to Law 360 as false. Rosen told Law 360, quote, both sides asked for a mistrial, which the judge granted today. The lawyers were brawling. Pointing to a motion he filed last month alleging, quote, snide comments by defense counsel. Quote, I disagree with Kazarian's statement. I don't want a mistrial per se, but there were so many different attempts to make this into something that it was not. He added that Kazarian wasn't there for all of the trial and she didn't know what she was talking about. It goes on to say defense counsel Steve Beliov of a different law firm that represents the Geragos and Geragos law firm did not answer questions about the mistrial. Quote, the judge declared a mistrial and I guess we'll have to leave it at that. Kazarian told Law 360, great for you, Kazarian. Thanks for bringing the tea. Told Law 360 that the judge said the state bar would be informed of the incident and referenced a recently approved rule, the new snitch rule, the post-Girardi snitch rule, which requires lawyers who have credible evidence that an attorney is engaging in misconduct to report it to the bar. California was one of the few states that did not require attorneys to tell on one another. They added that rule after the Girardi, all of the things. Monday's mistrial comes more than 2 weeks after opening statements. Holy shit. A 2-week trial that ends in a fucking mistrial because of attorney bad behavior. Wow. The waste of everybody's time. Monday's mistrial comes more than 2 weeks after opening statements kicked off June 23rd in a lawsuit filed by the family of decedent Anissa Farhadi, who died at the age of 21 in November at West Hills Hospital 3 days after she was admitted following complications of abdominal pain. So this goes through the underlying case. We're not going to get into the underlying case as for our purposes. What happened with the sanctions and the fight is the thing we are focusing on, not the underlying malpractice lawsuit. Let's see. On Monday morning, jurors and members of the public were ordered to wait outside the hallway as the court proceeded in closed session. At 10:30 a.m., the court began calling in each individual juror one by one to speak with them. What did you see? At noon, after the court interviewed all 12 members of the jury panel plus 4 alternates, Judge Recana excused the jury and thanked them for their service. The instant jury trial that opened June 23rd at times has been contentious, with plaintiff's counsel filing a motion in limine on June 28th. You in trial? That's after opening. What are you doing? Asking the court to preclude Geragos and Geragos and its defense team from making more snide comments of any kind that are disrespectful to plaintiff's counsel. You needed my phone? Okay. That are disrespectful to plaintiff's counsel or the court as they have done in front of the jury on June 28th, 2023. The plaintiff's counsel, Ron, who we're going to be talking about all day, also moved for new trial on June 28th, given the prejudice that occurred thus far that cannot be undone. In his motion, Ron complained that defense counsel and, quote, their witness, Mark Geragos, who testified the prior day, had made comments to him. He further claimed that defense counsel told him to shut up in front of the jury and that they made serious false allegations about or against plaintiff's counsel. So what he said is, everything that lawyer said is wrong, but these lawyers were picking on me. Okay. So that was the beginning of the mistrial of the malpractice lawsuit due to the attorney scuffle. Now, 2 days after that article, July 12th, we get a more in-depth article and motions. We're going to look at those in a minute. Geragos judge told of Schoolyard-Style attorney altercation. July 12th, 2023. Remember, plaintiff's counsel in the case we are talking about is plaintiff's counsel for, or in the Cardi B case, for Imani Ellis, who we are going to be talking about sanctions being requested against in the next motions. Attorneys for Geragos and counsel for a family suing the firm for malpractice laid out competing accounts Wednesday of a courthouse altercation that led to a mistrial, with a defense attorney alleging that plaintiff's counsel knocked off his colleagues' glasses and stomped on them. Well, the plaintiff's counsel were called a purely verbal spat. Now, it's not lost to me that this is the opposite situation of the Cardi B case. In the Cardi B case, his client is saying, she touched me. And Cardi B is saying, no, I didn't. I yelled at you. I didn't touch you. And that's exactly what plaintiff's counsel is saying here. Plaintiff's counsel is saying, we yelled at each other. That's the same plaintiff's counsel. Defense counsel is saying he knocked off glasses and stomped on them. Wednesday's hearing comes 2 days after Judge Recana declared a mistrial in a contentious legal malpractice suit accusing Geragos of botching an underlying medical malpractice case alleging a hospital caused the death of a young woman in 2013. That case was ultimately dismissed. So the underlying med-mal case. So the med-mal case was dismissed, and then they are suing the lawyers after the case was dismissed. That's the underlying. Judge Recana didn't explain the reason for the mistrial in open court, but recused himself Monday from further proceedings in the case. Geragos attorney Kazarian told Law 360 that the mistrial was prompted by a purported physical altercation Friday initiated by plaintiff's attorney Ron against Steve Belyaev, the attorney representing Geragos. She said she didn't observe it, but was there on Monday. At a hearing Wednesday, on Ron's ex parte motion for the judge to reconsider his recusal and remain on the case, attorneys from both sides fleshed out the details of their starkly conflicting accounts of last week's courthouse hallway incident. Now, the lawyers have lawyers. So Steve is the lawyer for the lawyers from Geragos. And Steve now has his own lawyer, another Steve, Segura. So Steve hired Steve, and they're all representing Geragos. No, Steve is representing Steve, and Steve is representing Geragos. Good Lord. It's like Brian's in Massachusetts. So Steve's co-counsel, Steve, told Judge Recana that he personally witnessed the altercation and said it was initiated by Ron. This is like when your kid or friend or colleague tells you a story about a bunch of people you don't know, and they're like, oh my God. And so then Steve said that he saw Ron hit Steve, and Ron said, and Steve said, so Steve, second Steve, told Judge Recana that he personally witnessed the altercation and said it was initiated by Ron. He said he witnessed Ron approach Belyaev, Steve, quote, in a very aggressive manner, and called him a bitch and said, do you want to get a piece of me now? In the hallway of the court, the attorney whose closing argument was, Cardi B cursed, is approaching opposing counsel, calling him a bitch and saying, do you want to get a piece of me now? And the other attorneys and jurors witnessed it. So witness Steve is saying he believed Ron was trying to start a fight. Of course he believed Ron was starting to start a fight. Ron was acting like he wanted to start a fight. You don't go up into the hallway to opposing counsel and be like, what, bitch? What are you doing? California should really implement mandatory therapy for attorneys. Like, get a hold of yourself. It's completely unprofessional. Do you want to get a piece of me now? As if he was trying to start a fight. So then Steve says that Ron spun Bellylove, the other Steve, around during the altercation and knocked Steve's glasses to the ground, Segura told the judge. Segura said he also witnessed Ron walk over to the ground where Steve's glasses landed and intentionally stomped and kicked them. Dude, putting hands on somebody is ridiculous. Stomping on their glasses is next level ridiculous. And I wonder if by spun around, Steve was trying to walk away. It's like, what, bitch, you want some? It's like, dude, we're adults. And tried to walk away. And that's when he got spun around. I just am wondering. But the stomping on the glasses, A, the time to replace the glasses. B, the fact that you now have to drive home without being able to see. It's so, ugh. Stomped and kicked the glasses. Then, as soon as sheriff's deputies came into the hallway, Ron started accusing Steve of the contact. Oh, so the second the sheriffs show up, he's like, he did it. Based on everything we've seen in court, I 100% believe it. I 100% believe the second that the sheriffs show up and is like, what is going on here? He's like, he did it. 100% believe it. Jenny said he did this in the courthouse. It's in the hallway of the courthouse in front of the jurors on their trial. He did it. As soon as sheriff's deputies came out into the hallway, because there were sheriff's deputies in the courtrooms, Ron started accusing Steve of the contact, that he was making an excuse for what he did and hoped things got broken up. Segura told the judge, that's what I saw. I would testify to that under oath. That's it. That's what happened. Meanwhile, Ron maintained that the altercation, words were exchanged. This was nothing more than a verbal argument between counsel. Ron said that he believes he and Steve are colleagues and friends who share the same Jewish faith. So let us get this straight. The witness said that you initiated a fight. An altercation. You stomped somebody's glasses, you called them a bitch in the hallway of the courthouse, and then when the sheriffs arrived, you tried to blame the other party and then say, we have the same faith, it's fine? Are you kidding me? The wildness. But what? Sir, come on now. The phone has returned. Okay, thank you. Okay, let him know. Okay, thank you. Thank you. I know. Yeah, thank you. Thanks, B. So, we have seen this counsel behave similarly in the Cardi B case. Dr. B was letting me know that T has an appointment today. So he was reminding me that we have a hard stop. So, he's like, it's fine. We have the same faith. That doesn't make it fine, sir. Ron told the judge that he disagreed with Steve and witness, I guess, but Steve's, quote, version of what he thinks happened. Adding, quote, I don't remember anything physical happening. Chat, break down this statement with me. Break down this statement with me. I don't remember anything physical happening. Doesn't say nothing happened. Version of what he thinks happened. I don't remember anything happening. I can't say it, Your Honor, I don't remember. It's couching. It's not, I didn't touch him. Dara in the chat said, he's quoting Thor. He's a friend from work. I can't recall. We're all friends here, but I can't recall. Ron goes on to say, the only thing I did here is one of the jurors said that Steve struck me. Oh, so you recall one of the jurors saying something? I bet that juror didn't say that to the court because all the jurors were interviewed before this. The attorney further argued that if opposing counsel continues to, quote, push the issue, then I'll have all the witnesses confirm what he did to me, and I'll leave it at that. So let me get this straight. The second that the sheriffs arrive, you blame the other party. Then you say it's fine, we're all just friends and we have the same faith, it's good. Then you say, but if he keeps pushing it, I am going to go after him. So deny, blame the other side, and then threaten them. Wow, sir, this pattern is pretty familiar to what we saw you do in trial. Pretty familiar pattern, isn't it? He did it. I didn't do it. But if you keep doing it, I'm going to go after you. So there's the threats. There's the threats at the end. Ron says that he specifically disputes the witness's account, calling him a biased witness. Oh, and that witness is biased. That witness is biased. He said that both witnesses, Steve and Steve, have a dog in this fight because they're from the same firm. You tried to say y'all were friends because you're from the same faith. Ron also asserted that Geragos and Geragos were pushing Kaufman Dulwich, the other firm, to have plaintiff's counsel reported to the state bar and have the case assigned to a different judge. If you put hands on someone, you should be reported to the state bar. You should be. Ron goes on to say, even from what he said, there's nothing really physical. So my version of what occurred was, I'll say, I did nothing wrong. Ron said there was nothing physical. I'm not allowed at this point to speak against Steve about what he did, but I'm just going to say I didn't do anything physical. Steve, however, maintained that he never laid his hands on Ron, quote, but he did lay hands on me. Steve added he had no problem with Judge Red Recana reporting the incident to the state bar under the new snitch rule, which requires lawyers that have credible evidence of an attorney's engaging in misconduct to report it to the bar. Steve said, I have nothing to worry about, so if it's reported, it's reported, adding that he thought the judge made the right decision in recusing himself. Quote, but as far as returning to your courtroom, Your Honor, I think there's just been too much drama, Steve said. I think that because of what happened with the jury, I think this case needs a fresh start in and out of the courtroom so that the issue of what happened last Friday isn't lingering over the proceedings. And yeah, if the judge ends up a witness in state bar proceedings, it's a problem. Wednesday's hearing stems from Ron's ex parte motion, which means just to the court. Ex parte motion filed Tuesday urging Judge Recana to reverse his decision to recuse himself from the case after the mistrial was declared. Ron wrote in the filing that he and his clients have great respect for the judge and want him to continue presiding over the case. Geragos and Geragos opposed the ex parte, writing that the judge had on Monday highlighted that the fact that he himself, along with court staff and the court staff from the neighboring courtroom, were also witnesses, which means it was so loud in the hallway that everybody came out of the court. Right. And then everyone in the entire courthouse is going to know what's going on because courthouses, gossip travels like hospitals. Everyone knows everybody's business. So his court and the neighboring courts are all witnesses and would be witnesses in the forthcoming state bar proceeding. Ron's ex parte is, quote, a legally forbidden request to have the judge keep the case that he no longer has jurisdiction over. Once the judge has recused himself, the judge can't hear any other matter on the case. So asking him to reconsider the recusal, the judge doesn't have authority over the case anymore. He doesn't have jurisdiction, like actually doesn't have jurisdiction. On Wednesday, Ron said he's hired private counsel since the incident and implored the judge not to report him to the state bar, claiming that, quote, he did research on the new reporting rule, spoke with a state bar attorney, and the rule doesn't go into effect until August. Why are you so worried about the judge telling the state bar? He also claimed that the state bar's reporting requirement doesn't apply to judges. Quote, I'd ask there be a lesser sanction of some sort if the court wants to, Ron said to the judge. Quote, there's no reporting requirement. You don't have to recuse yourself. And I'm going to say it. You're my favorite judge in the entire courthouse. That's what it is. And the plaintiffs feel the same way. And they want you to be the judge on the case. Please don't tell on me. You're my favorite. Please don't tell on me. Sir, this might have worked in second grade. Please don't tell the bar. You're my favorite judge. Was he also batting his eyelashes? But Your Honor, you don't have to. Sir, act like a professional and you don't have to worry about it. Ron urged the judge to consider the personal impact on reporting him to the state bar. I'm a young attorney. I'm 47 years old. I have time to get married and have children, and I don't want my reputation tarnished. But Your Honor, why? Why would you do this to me? I'm 47 years young. Can you hear my cat meowing? Even my cat is like, what the fuck is happening? Ron added, the state bar takes what a judge says very seriously. Hey, T. Oh, the cat's meowing at you. Glad you're home. Hello, George. Hello, T. All right, go get some food. How you feeling? Meh. Terrible. All right, go lay down. I know. Yeah, I'm glad you're home. Go lay down. All right, T's home. Mm-hmm. Yep. All right, buddy. I thought the cat was meowing at me. I didn't realize T was already home. So the cat, T is home because I'm taking him to the doctor later today. So George is thrilled that he is home, but George is also like, why are you talking to her and not petting me? Rude. Continuing to talk about Ron. I'm sorry. I'm a young attorney. I'm 47 years old. Do not tarnish my reputation. He says 2 years before he's on camera in, at least 720 in the Cardi B case. Ron goes on to say the state bar takes what a judge says very seriously. So you're going to try to make the judge feel guilty. You're going to try to make the judge feel guilty for reporting you to the state bar for your own behavior. Your Honor, think about the damage it will do to my career. Well, you should have thought about that before you allegedly put hands on people. And then he goes on to say, but Your Honor, you're not even a witness. Let's get to that. Your Honor was never outside the hallway, Ron said. I remember vividly. I looked for you. You were not there. Sir, what? Did you look to the judge to see if he would catch you calling co-counsel or opposing counsel a bitch? The judges never come out the front doors of the hallway. There's a whole back hallway system. We have talked about the back hallway system. The judges have a whole hallway. There is no reason to believe ever that the judge is out in the front hallway of the courtroom. There is no reason to ever think that the judge would be out in the front. I looked for you. Save me, Your Honor. Fly in on your black robes. I remember vividly. I looked for you. You were not there. You never saw anything. So everything is based on what you've heard. And I'm telling you, as an officer of the court, this was a verbal argument. Every single tactic in the book. We're not done yet. And more than that, I can say, because that would be against my Jewish religious beliefs, but I can speak for myself that there was nothing physical from my end. You didn't see it. I didn't do it. Believe me, think of the consequences. It's against my religion. At the end of the hearing, the judge was sick of this bullshit. I'm sorry, that's not what the article says. At the end of this hearing, the judge denied the motion and the request to strike the opposition from the record before commenting that in his 41-year career, on the bench with countless trials and maybe 5 mistrials along the way, I've never recused myself in any of those 5 cases after the fact. This is so bad, the judge said. This is so bad that I have never, literally in 41 years, I have never. The judge says, as much as he likes to keep all cases assigned to him and presides over jury trials, Judge Recana said he didn't think he was in the best position to do so with this case in the interests of justice. Judge Recana also advised Ron that despite his claims that the state bar's new rules don't apply to judges, the court does indeed have an obligation to report the incident to the state bar, whether you like it or not. And the state bar is the appropriate authority to address attorneys' conduct. At this time, I can only wish you all the best. Judge Recana told the parties, you need a fresh start. Ron declined to speak to Law 360, but his client told Law 360 in a phone interview that he observed the exchange between the attorneys and that Ron did not hit Steve or anyone else. Well, that's not the allegation. The allegation isn't that he hit Steve. It's that he put hands on him and then stomped on his glasses. So no, I agree. I don't think he hit anyone. He grabbed them. Farhadi told Law 360 at the end of the trial Friday afternoon, Steve approached Ron inside the courtroom and told him, you're a piece of shit. After the attorneys walked into the hallway outside the courtroom, Farhadi said he saw Steve with a bent arm push Ron in the area of the chest and stomach. And then he said he positioned himself between the attorneys to prevent further contact, and then the sheriffs approached. Steve told Law 360 Wednesday that description of the alleged dispute was not true and denied pushing Ron in the hallway. Steve said the trial was out of control and that Ron made comments to the defense team throughout the proceedings that he believed were inappropriate. And after the judge and jury left the courtroom, as the attorneys were packing up their briefcases, he and Ron began to exchange words that were not pleasant. Steve said, I made a comment to Ron, it has his name in the article, but to Ron about statements he made about me in front of the jury without getting into any detail. We exchanged words. I packed up my bags and walked out of the courtroom. While I was waiting for my colleague, other Steve, witness Steve, Ron stormed out of the courtroom, got right up into my face, nose to nose, and started yelling at me, and that's when he pushed me. In a statement to Law 360 late Wednesday, Kazarian, who gave the other statements, who served as a corporate representative of Geragos and Geragos during the trial, said Ron made, quote, a mockery of this trial and is a menace in the hallways. His attempt to erase the evidence this morning failed, and his baseless request was denied. I think there's only one option. We need to look at the evidence that he tried to erase and the declaration that he tried to have removed from the record, because I think that's what we have to look at next. But before we do, we do have a sponsor today. I'm going to pull that up while I tell you about our sponsor, June's Journey. A huge thank you to today's sponsor, June's Journey. Look, I know when we are going through all the different cases, I often caution against trying to solve the cases that we are watching play out because there is process and we are just here to witness and talk about the facts. But that's not the case when it comes to June's Journey. June's Journey is a hidden object mystery game with a captivating detective story taking you back to the 1920s. And as you are moving through the story, you are unraveling a mystery that finds June in a quest to solve the murder of her sister and uncover her family's many secrets. I love the hidden object and seeing how fast I can find all the different hidden objects. It always gives me a way to test myself to see if I can get faster. And then uncovering the bits of the story while you also get to decorate things. It has all of the components of a game that I love. It's time to check out June's Journey. And if you want to, you can add other Law Nerds as friends in the game. So I will make posts for you guys to do that or check it out in the chat so that if you want to game with the other Law Nerds, you can. So if you're ready to check it out and get gaming, download June's Journey for free using the link in the description or by scanning the QR code. It's available on iOS and Android devices as well as PC. So thank you to June's Journey for sponsoring today's stream. We should get back to it. I should have added that June's Journey will keep you from being a menace in the hallways because you will be too busy trying to solve the mysteries and decorating. So, menace in the hallways is where we left out. Let's look at the opposition that attorney Ron Rosen tried to have stricken from the record. And a huge thank you to June's Journey because sometimes YouTube hates the things I say. Let's get to the filing. This is from July 11th, 2023. As we go through the background before we look at the other sanction motions, I'm trying to move the, oh, I put it in the wrong place to move it over. That's on me. Hold on. Let's see if we do it this way. If it'll just ship. Nope. That's not going to make it better. Apologies, chat. It's on me. Because I didn't download it. I just grabbed it. Defendant's opposition to plaintiff's ex parte application for Judge Recana to reconsider his recusal. This is what they tried to have stricken from the record. Introduction. The court recused itself on July 10th, 2023, and no longer has jurisdiction to hear plaintiff's motion. Plaintiff's ex parte motion is therefore not before the correct court. The court previously admonished plaintiff counsel from seeking to communicate after the recusal was made. This is procedurally so improper. And the court's like, you can't do this. And then he's like, I'm going to do it. Anyway, on June 22nd, jury selection and plaintiff's legal malpractice action against defendants and Mark Geragos began. Since the onset of the trial, plaintiff's attorney Ron Rosen, Janfaza, has continuously and methodically made a mockery of the proceeding and has made every effort to have a mistrial declared in the case, including a mistrial request of his own, citing baseless accusations and devoid of all case law, and relied on unprofessional tactics to delay the trial on numerous occasions. As a side note, plaintiff's counsel in this exact case was sanctioned, not for this, but sanctioned for other discovery fuckery over $22,000. So plaintiff's attorney in this same case was sanctioned. And then that went up on appeal, and then that was upheld because of the discovery tactics that were unprofessional. So he was sanctioned in this case for behavior before all of this went down. So when they're saying he was delaying proceedings, et cetera, that's consistent with the sanctions that were ultimately found. So it goes on to say that he asked for a mistrial, and just on the like vibes, D. Russ said, wait, Ron was sanctioned. Yes, Ron was sanctioned in this case over discovery issues. He was the plaintiff's attorney in this malpractice case. So continuing, they say he relied on unprofessional tactics to delay the trial on numerous occasions, wasting the jury's, defendants, and the court's time. We saw him delaying things in the Cardi B trial too. Plaintiff's attorney attempts to implode the trial were finally successful when he engineered a mistrial by physically attacking defense counsel, Mr. Steve Belov, in the hallway of the courthouse in front of at least one juror after the conclusion of proceedings on July 7th, 2023. As a result of his actions at the beginning of court July 10th, the court, upon its own motion, without any input from counsel, announced that it would be conducting a closed session hearing to take testimony from each juror individually and would be forwarding the transcripts of the proceeding to the state bar. Judge Recana also advised the parties of the latest ethics rules that require the victim of the assault to report the aggressor to the state bar. A hearing was conducted where it was determined that one juror was a percipient witness to this assault, and at least 6 jurors heard about and discussed the incident among themselves. Defense counsel then moved for a mistrial. Of course the jurors were like, holy shit, the lawyers are fighting in the fucking hallway. Of course they were. Because the jurors are just like, what the fuck? Judge Recana ruled that a mistrial was not only appropriate, but required, as was his own recusal in the case, highlighting the fact that he himself, along with court staff and the court staff from neighboring courtrooms, were witnesses and would be witnesses in the forthcoming state bar proceeding. Plaintiff's attorney requested to be heard after the ruling, and Judge Recana appropriately denied the request, citing his lack of jurisdiction as he had been recused. Once you are recused, you are no longer in charge of the case. It has to go to a different judge. So being like, but wait, Your Honor, just one more thing. No, there's no but wait, one more thing. You've been recused. Plaintiff's attorney now makes a legally forbidden, nay, foreboding, ex parte request to have Judge Recana continue to rule substantively on the case he has been disqualified on. Right. Accordingly, plaintiff's ex parte application must not only be denied, but it cannot be heard by the judge. They go on to cite the rules. I agree with them. The judge recused themselves. They cannot hear a motion on the case. And they say that plaintiff's counsel purposely misstates the law in his motion. Shock me, shock me, shock me. Conclusion, we can't hear this case. I am not surprised. So, that was the underlying 2023 facts. And Helzit Leaf said, would talking about the fight between attorneys be a violation of the rules for jurors? I think that when it comes to jurors talking about the case, that a lot of jurors would be like, but we're talking about the lawyers, and we just saw that happen. So I think a lot of jurors might not think that they're talking about the case because they're not talking about, do you believe this person? Do you believe that person? Do you believe any of this? It's like, wait, what the fuck is happening? So I really don't blame the jurors on that. technically, should they be talking about what the attorneys are doing? No, but the situation is so fucking wild. I mean, you're not going to tell the jurors, oh, and by the way, if the attorneys are up to no good, you can't talk about it. Like, what? So I'm gonna raise the desk a little bit. Okay. We're going to go on to the next motions from the Cardi B case. Lolly looked up his background. He graduated from UCLA and then Loyola. Loyola Law is also where Tom Girardi went, and that's no shade to Loyola Law. Loyola Law is a good law school. But what the fuck? Like, lawyers are on their own on this. So, also, just because you go to a school that's ranked pretty well does not mean you have common sense. The sense seems to be lacking. We're going to pull up the filings in the Cardi B case. So as we swoop over to the Cardi B case, this same lawyer, the defense attorneys, Cardi B's attorneys, are asking for sanctions against. We saw the beginning inkling of this in trial, where the judge said any conversations about sanctions will be later. And I sat here going, sanctions, 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 sanctions. And the beginning of that process is supposed to start on Friday, but the filings are in. And because the filings are in, we're going to go through them. So I'm going to go through these in a slightly different order than I normally do because I want to. So let me tell you the order I'm going to go in, because there is a 69-page affidavit that includes transcripts. So I'm going to go through the affidavit first, and then we'll skim through the motion. The motion is going to reference the affidavit, but I think we should go through the transcripts first. We can go like law after that, but transcripts first. And then we can skim through the law, because the transcripts are going to have everything that we want to know anyway. They're going to be summarized in the motion. The motion uses the signed affidavit to back up what is said in the motion. So I feel like we just go to the affidavit first. So that's what I'm going to do. We're going to pull up that affidavit, and then we're going to look at the responses after that. Why? I have verified that it's me like 7 times today. Why is my computer's like, but is it really? But is it really? But what about now? Yeah. All of my multi-factor authentication is doing the most today. The absolute most. All right. Not 6'7", but 6'9". Filed October 2nd, 2025, ahead of the hearing scheduled for Friday, October 17th. This is in the Imani Ellis Cardi B case. Post-trial litigation, the lawyers are fighting, though this time not physically, just with their words. Declaration of Peter Anderson. Mr. Anderson is Cardi B's attorney. Ron is the attorney for plaintiff in this case, Ms. Ellis. Peter Anderson says, I am an attorney. I am an attorney with this law firm. I defended Cardi B in this action. If called as a witness, I would testify to what follows. The declaration is submitted in support of Cardi, and I'm just going to refer to Cardi B as Cardi B because Cardi B asked in court. Just refer to me as Cardi B. Sure. Participated on behalf of Cardi B in the trial of this action, which began August 25th, 2025, ended September 2nd, 2025. I covered it later because we were covering Donna Adelson. The jury returned a verdict in Cardi B's favor. I'm familiar with the court rulings in this case, the evidence admitted during trial, and the discussions. Violations of motions in limine orders. This is Cardi B's attorney asking for sanctions against plaintiff's lawyer. Count 1. We heard about this in trial. It was wild. We were supposed to zoom through that trial and through the lawyer argument. And then it got fucking wild. And no zoom happened, and we streamed for like 9 hours a day. It was fine. Violations of motions in limine order. Count 1. Cardi B's pretrial motions in limine included her motion in limine number 1, filed July 1st, 2025, seeking an order precluding plaintiff, Ron, and, plaintiff, Miss Ellis, and Ron, her attorneys, from referencing to, arguing, or introducing any other evidence at trial regarding any former association with a gang or gang members during her youth. And then they cite the motion in limine. On July 30th, the court granted that motion in limine, conducting or concluding that any references during the trial to Cardi B's, quote, prior acts and alleged prior acts, as well as any prior involvement in exotic dancing or any gang associations that have no apparent probative value, and any references thereto, would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. So the court said, no. You're not referencing any of this. None of this has anything to do with whether or not she scratched the plaintiff in this case. That's the order. Remember, the court told the attorney, you violated the order. And the attorney goes, no, I didn't. And the court said, nope, reread the order. That was the court's nope response. Go reread it. On August 26th, Ron began his direct examination of Cardi B by asking, question, do you have any affiliation at this time with a gang? Mr. Anderson, objection, Your Honor, motion in limine. That violates the motion in limine, the order. The court, sustained counsel, you know better. Footnote 1. And we paused on this, and I imagine that we also have a timestamp to it on that day of trial. Footnote 1. References in this declaration to exhibits refer to the exhibits attached to this declaration, which are true and correct copies of the designated pages of the transcript of the trial. We'll get there. The cat lady said, I can only assume Ron was trying to make Cardi B look bad. That's exactly what he was trying to do. He was trying to make the jury think that, ooh, she's a bad person and she must be scary and angry and aggressive and assaultive because she's affiliated with a gang. It was hard. It's exactly everything he was trying to do is the reason the judge said it's not relevant here. You can't try to taint the opinion of a person by being like, look, bad person did bad thing. Therefore, they did this thing. You can't do that. So the judge said, you don't get to do that. So that was footnote 1. Ron argued that he did not violate the court's order number 1 because the order, listen to this argument, you guys. Because the order only prevented him from asking Cardi B whether she used to have gang affiliation and not whether she is presently affiliated with a gang. Your Honor, you said I can't ask if she used to have affiliation, but I can ask now. Here's the thing. You need to have a reasonable belief and an evidentiary basis to ask the question. And if you don't have an evidentiary basis, you can't ask the question. Does he have any basis for that question in evidence? Not that she did or didn't, I have no idea. Like, I know Cardi B from her music and from clips from her on reality TV where she's funny as fuck. I don't know whether she did or didn't. I don't give a fuck. But does he think that she currently does? And based on what? Because I don't think he has evidence to that effect. So he is trying to play semantics with the court. And I don't think the court is going to be welcome to that. Right? Because the court very clearly said, this isn't relevant. There's no probative value, and it's unduly prejudicial. That's going to apply to any gang associations. Any. No apparent probative value, unduly prejudicial. So at a minimum, if you are unclear, you don't say that shit in front of the jury. You ask the court, Your Honor, outside the presence of the jury or at sidebar, I believe this for this reason, and I need to ask this question of this witness for this reason. You do not do it in front of the jury. So if you are ever unclear, law is not an ask forgiveness kind of a situation. This is an ask permission kind of a situation, especially in front of the jury. So he argued that he didn't violate the court's order because semantics. However, as noted above, in granting the motion in limine, the court concluded any gang associations are irrelevant and would be unduly prejudicial and likely to confuse the jury. July 30th, 2025, minute order at 3. As a result, Ron knew his question as to present gang affiliation was improper. Further, no evidence was adduced in discovery or at trial that would provide, oh, he got there. Keep reading, Emily. That would provide Ron with a good faith basis to ask such a prejudicial question at trial and in the jury's presence. Nor did he advise the... I really should have kept reading. Nor did he advise the court or defense counsel beforehand that he intended to ask about gang affiliation or provide an offer of proof as to a good faith basis to ask that question. And honestly, what other people might have said it is not going to be a good faith basis. You would need to have like evidence. Cardi B's pretrial motions in limine also included her motion in limine number 3, seeking an order striking Dr. Alex Avila from plaintiff's untimely expert list. Untimely! And declaration, and precluding plaintiff from introducing at trial the testimony of Dr. Avila. The court granted Cardi B's motion in limine number 3. See July 30th minute order at 4, tentative, and 5, granting the motion in limine. As a result of Ron's failure to timely identify the doctor or seek leave to argue his prior expert disclosure or augment his prior expert disclosures, plaintiff did not have an expert psychologist. So, discovery issues. This is what plaintiff had previously been sanctioned for in the amount of $22,000 in the other case we were just reading about. He didn't turn over the expert in time, and the court blocked the expert from testifying. This is more common in civil cases than criminal cases. So, another motion in limine. However, on August 25th, 2025, Ron unilaterally submitted to the court a purported, quote, joint witness list. It's not joint if you don't meet and confer with the other side. That's just your witness list. And trying to say it's a joint witness list is, I think, misleading to the court. If you say this is a joint witness list, it needs to be agreed upon by both parties. And you're saying to the court, we've agreed. And then you're saying to the court, we've agreed to a witness that's already been barred by the motions in limine. It is an additional misrepresentation. It's not the biggest one. It's just another one. So he unilaterally submitted a joint witness list not endorsed by defense that included the doctor as a witness, even though the court's July 30th order precluded Ron from calling the doctor. In addition, during the trial and lacking an expert psychologist, Ron repeatedly included in his questions to multiple witnesses his own references to the doctor, including in his questions that false suggestion that the doctor had treated plaintiff. Count 3. Question. Did you also treat with different psychologists, including Alex Avila and other psychologists on October 8th, 2023 through July 2nd of 2023? Completely improper question. Count 4. So they're saying each of these is a violation. That's why they've put them in counts. Each of these is a violation. That was asked to the plaintiff. This is a second time it was asked to the plaintiff. Did you seek treatment from psychologists, including Alex Avila and other psychologists from October 8th through July 2nd? Count 5, asking a different witness. Did you review any medical records from Dr. Avila, any psychology or any psychological treatment? Count 6. If you can go to Exhibit 3, did you review any medical? Sorry, withdraw that. Did you review any psychological records from Premier Forensic Psychology from Dr. Alex Avila? Count 7. Yeah, I'm talking about the medical records from Mr. McKenzie, the psychologist, the medical records from Dr. Avila, a psychologist, the medical records from Dr. Mulligan, a plastic surgeon, and the medical records from Dr. Normand, pain management doctor. Did you review those records? You testified a minute ago, yes. And the question is, did you use, the all caps, these 4 medical records in formulating any of your opinions that you testified about here in court? Count 8. Question. She went to Dr. Avila, another psychologist, and she went to his office and got treatment from other providers that were under him for a total of 12 treatments, correct? Count 9. And she received from your review of the medical records 12 visits from Dr. Avila's office and staff, correct? You testified to that. 9 times. 9 times. Improper closing argument. I have never seen so many sustained objections in a closing. And because we watched the trial in 2 days, we were sitting here going, that's not what they said. That's not what they testified to. That's not in evidence. Like, I was objecting as much as he was objecting. Fucking wild. Improper closing argument. As raised, Jenny Marie said, Emily, you said 9. I thought you were saying no in German. No, not that 9. Ferris Bueller's. He's been absent 9 times. That one. But also short. You raise the accompanying memorandum points in authority, or as raised in the accompanying memorandum P&A prior to closing argument, the court admonished, and we're going to go through that later. The court admonished, and we watched this too, Mr. Ron, not to argue facts not in evidence. This is well known. You shouldn't have to tell a lawyer, hey, by the way, rules. They mean something. Don't fuck it up. Like, the court admonished the attorney to not argue facts not in evidence. And we're going to see the transcript of that because it's attached. Yet, Ron proceeded to do just that. I mean, they knew what was coming, right? They had this dude's number. It was not engine number 9, apparently. In his closing argument, Ron made appeals to jurors' sympathies and biases, misrepresented the evidence, expressed his personal opinion, and claimed knowledge of a disputed fact. Indeed, in apparently less than an hour of closing argument, the court sustained 18 objections, averaging approximately 1 sustained objection every 3 minutes. I love that they counted. Ron's statements or 18 objection, one sustained every 3 minutes to Ron's statement, specifically on September 2nd during closing arguments, count 10. In his closing, and despite the court's order in limine and the court's direction not to argue facts not in evidence, Ron argued that plaintiff saw Dr. Avila during his closing arguments. Not only was it not in evidence, but the court specifically ruled against it. Specifically excluded this doctor, and he's just trying to slip it in closing arguments. From the transcript, quote, now, in addition to seeing the 2 plastic surgeons and Dr. McKenzie, Ms. Ellis also received another 12 visits. She testified that she saw a psychologist, Dr. Avila. Mr. Anderson, objection, Your Honor, the court sustained. Mr. Anderson, violation of the court's order. The court, move on, counsel. The court was telling Ron to move on, not Mr. Anderson. Count 11. In his closing, Ron argued facts not in evidence regarding plaintiff's background. We objected to this too. Quote from the transcript, if you recall, just to give you a little bit of background about Miss Ellis, when she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor. Objection. There's no evidence of that. The court sustained. He could have asked her about her background. He didn't, and some of it's not appropriate. But you can see why he's bolstering his client this way, because then he started talking about how pearl-clutchingly appalling Cardi B's cursing is. Oh no, she cursed. Come on. Count 12. In his were any of you offended by Cardi B's recitation of what happened in the way counsel asked her? The time I've been appalled by cursing in court, honestly, I'm rarely appalled by cursing, but I think Proctor trying to avoid saying see you next Tuesday. I think Proctor trying to avoid cursing in court offended me more. Because Proctor was trying to downplay the things he said in his horrific text messages. And I was mad at the text messages. I wasn't mad that they were being read in court. I was mad that he said it. A lot of you are saying way more offended by counsel's questions. Fair. A lot of you are more offended by questions by counsel than Cardi B. Very fair. I bet the jury was too, right? I mean, obviously, they were just like, done. In closing, going on to count 12, Ron argued facts not in evidence regarding alleged embarrassment and emotional injury supposedly sustained by plaintiff, stating his own personal knowledge or belief as to probable embarrassment and emotion. This is not appropriate, especially when emotional damage, I need to put that on the soundboard. I need to put emotional damage on the soundboard. But when you're looking at a civil case and emotional damage is part of damages, you have to have facts that support it because it's part of the case in chief. This is from closing. Quote, the facts are Amani Ellis was working as a security guard. There was a change, okay? It's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, Mr. Anderson, objection, Your Honor. Mr. Rosen, the pain the court sustained. Count 13, in closing, Ron argued that the jury should, quote, show respect to security personnel, contrasting them with doormen or doorwomen, like 3 or 4 times. What the fuck doorman pissed this dude off? He was like, they're security. They're not just some doorman. Sir, I'm sorry. How about treat people with respect when they're at work? It was such a weird fucking argument. They go on to argue that this was an improper send a message appeal to passion and prejudice. We also I also argued about this during the closing arguments in-depth heard because Rottenborn was doing the same thing, like send a message to everyone out there. That's not what jury verdicts are for. That's not what they're for. It's to send a message to these parties. That's it. But he was arguing that the jury should send a message. He also is arguing that this is an injection of personal opinion untethered to evidence. Or fact or reality. Quote, Ron, she was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. Mr. Anderson, objection, Your Honor. The court sustained. Yeah, Cardi did say she was security. Cardi said she looked like she could guard a building. Count 14. In his closing, Ron argued facts not in evidence regarding the technical ability of cell phones to record video. But Your Honor, I have a cell phone and I know that it can record video, so I can testify about it. In closing, Ron argued facts not in evidence regarding the technical ability of cell phones to record video. Indeed, even the make of plaintiff's phone in 2018 was not in evidence. And as to his own claimed knowledge of testing his cell phone, stating, I tried it myself. I know, I lost my mind. Ron, quote, the other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on a call. So it could be the two of them couldn't be done. Objection, Your Honor. At the same time, the court sustained. He's just testifying in his closing argument to experiments he did on his own phone in 2025 regarding an incident that happened in 2018. No. Count 15. In closing, he argued facts not in evidence regarding plaintiff's failure to offer into evidence supposed records of Dr. Cheer, a physician who plaintiff claimed she had seen, but who she testified had not treated her. Ron, closing, quote, during that time, she also saw Dr. Cheer, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in the open court, so that it's some sense of fairness why there's no records of Dr. Cheer. We watched the court's very limited stipulation on this, and the court told counsel, you are not to add any more to this. And then he sprinkled it all right in. It's exactly what the court told him not to do. Exactly what the court said. Mr. Anderson, objection, Your Honor, sustained. Count 16, facts not in evidence. Plaintiff's alleged lack of prior incidents. This never came up in court. Ron. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. That's improper vouching. She's a hardworking security guard who was doing her job with no prior anything. Objection sustained. There's two problems with that statement. Both of them are wrong. You should believe her is improper. No prior anything, also improper. Count 17. But when you have this much. Falsely stated that Cardi B testified at trial that the photo of her while she was in Los Angeles for the 2018 NBA All-Star Weekend was taken the same day of the alleged incident. Yep. Lost my mind. She never said that. She said it was the same week and she had the same nails the entire time she was here. Ron, it could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident. She never fucking said that. We watched it. Ron misrepresented to the jury. This is continuing. Despite the court's statement just a few minutes earlier that Cardi B did not testify to the date of the photograph. Look at this photograph. He's like, I did. And she said it was that day. She went to the doctor dressed like that. No, she fucking didn't. The court. I hate that this is in all caps. Well, I'm not necessarily worried about that. I'm just worried about whether I don't think that there was any representations of the date that was taken. She did just reference it generally, but the substance of the testimony was that she had those nails the entire time she was here in LA. So whether it was taken on one day or a different day, I don't think that's material. The court told him. In closing, he argued facts, not in evidence, to the purported emotional impact. Emotional damage. Sorry. The Stephen He shoutouts are plentiful today. It just lends itself to it. Ron, quote, and also, as a woman, she doesn't want to have a scar to her face and all the time, every day, waking up in the morning, thinking about so many things. Wait, no, Emily, no, that's not what we're talking about. Waking up in the morning, looking in the mirror, remembering the event. It reminded her. It does remind her. This is how you remind me. Sir, that's not what she said. If that was true, she could have testified to it. She's the plaintiff. But she didn't. You can't add to your client's testimony in closing. You know, these women and their vanity. Mr. Anderson, objection sustained. Count 19. Ron misrepresented to the jury that Dr. Finke testified that he recalled Cardi B's fingernails having protruding rhinestones. Ron, if you remember Dr. Finke, who was a fingernail, I think he said fingernail guy, that was his thing. And he basically said he remembers the rhinestones, that they were protruding. He didn't say that. Mr. Anderson, objection, Your Honor, misstates the testimony. The court sustained. Actually, Dr. Finke testified that rhinestones on fingernails can protrude or be flat, and he didn't recall. I can't do rhinestones that protrude because I will pick them. I will fuss with them. I cannot. So Dr. Finke, who is now forever heretofore going to be known as the fingernail guy, but I mean, it is what it is. Quote, do you have any recollection now, 7.5 years later, whether the rhinestones in that photograph on Cardi B's fingernails were actually three-dimensional or were flat? Ron, objection calls for speculation, expert opinion. Bro, it's not even the realm of the close right objection because you opened this door. The court overruled the witness. No recollection. He's like, I don't know. They were bedazzled. Count 20. Holy shit, we're only on page 9. Fuck. I need to read faster or I'm going to run out of time. In his closing, Ron argued the law by telling the jury that Cardi B was trespassing and legally obligated to leave, which is also not in evidence. Ron, quote, at some point, Cardi B caused such a disturbance that what she was doing was trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. Mr. Anderson, objection, Your Honor. The court sustained. Why don't you move on, counsel? Count 21. Misrepresented the testimony of witness. Miss Schmidt, plaintiff's mother, representing that she testified that plaintiff received a scar on her cheek as a result of an altercation with Cardi B. Ron, Miss Ellis's mother, Leanne Schmidt testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of the incident. Mr. Anderson, objection, Your Honor, sustained. The testimony included no such assertion, nor could it have, since she was not present at the time. In closing, count 22. Ron argued that Cardi B paid expert witness Dr. James Rosenberg $40,000, suggesting improper wealth insinuations as to Cardi B that Dr. Rosenberg makes millions of dollars, which was not in evidence. Ron, quote, the defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars. Objections, Your Honor, sustained. If he had left out the makes millions of dollars, that would have been fine. That is the least of the problems. Because you're allowed to say, look, it's a hired gun. He was paid a lot of money for his testimony. You decide. Count 23 in closing. Ron argued that some doctors will say they do not want to know their patient's issues, which is not in evidence. Ron, this idea that every time you go to a doctor, no matter what specialty, you have to cover all the things is not real. It's not real life. Some of the doctors will even say, don't tell me. I don't want to know. Stop right there. Thank you very much. If you are going to the doctor and you are currently distressed or having symptoms of distress, depression, etc., doctors will ask about it. It's never been my experience that doctors are like, please stop talking. And I talk a lot. Okay. Mr. Anderson, objection. The court sustained. Counsel, let's stick to what the evidence shows, which is a pretty bold statement in front of the jury because the court was already pissed, it seems. The court was like, again and again and again and again. Count 24 in closing. Ron argued facts not in evidence regarding purported costs for psychological care. In closing, Ron, quote, all right, and then I want to go over a little bit about the medical bills, so you don't have to get it exact. It doesn't have to be an exact number, but there was testimony in this case that Mr. Ellis had $17,500 in medical bills from Dr. Mulligan, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things. Objection, Your Honor. There's no evidence of that. The court sustained. Sustained. In closing, count 25. Ron argued that Cardi B has anger management problems, which was not supported by the evidence and also violated the court's in limine order by arguing character and suggested prior bad acts. Ron, in closing, this is in the middle of the sentence, but it's a who you're going to believe statement. Quote, or are you going to listen to somebody who was yelling and screaming, has anger management problems? Mr. Anderson, objection, Your Honor. The court sustained. 25 different counts. Prior notice of the application for an order to show cause upon conclusion of the trial in this action on September 2nd. Keep this in mind. In open court and after the court directed that Cardi B could within 30 days file a request for an order to show cause directed to Ron regarding attorney misconduct, I provided notice to plaintiff and Ron that Cardi B would timely apply for an order to show cause. The accompanying application is that application. In response to my notice that day that Cardi B would be filing an application for an order to show cause, sometimes I'll refer to it as an OSC, but it is the procedure to go through getting sanctions. In response to my notice that day, September 2nd, that Cardi B would be filing an application for an OSC to Mr. Rosen, Ron indicated he would oppose the application and file his own application for an order to show cause directed at me. If you ask for sanctions, I'm asking for sanctions. I declare under penalty of perjury, below is correct. Exhibit 1. Application for order to show cause regarding trial misconduct. Here are the questions about the wig. We have that timestamped, I'm sure, in testimony. This is the very beginning of Cardi B's testimony. Question from Ron. On the date of the incident, did you have black hair, blonde hair, or different color hair? Answer. I quite don't remember. I do know I had a hoodie on. And then she was telling him they're wigs. And he said, okay, sorry, I didn't know that. It's a good wig today then. Ew. Question. Do you have any affiliation at this time with a gang? Mr. Anderson, objection, Your Honor, motion in limine that violates the motion in limine. The order, the court sustained. Counsel, you know better. And these are all of the transcript snips regarding this. So this is the court talking about it. Ron, yes, Your Honor, my argument is that, and I've consulted with other lawyers about this, and everybody's pretty much in the same path of if the psych claim goes away, then those 3 doctors go away. It just wouldn't make sense. I'm not going to give up my claims and then have the doctors testify. That's my argument. If they're going to have these doctors testify, we'll just keep them and roll with it. The court, again, I don't want to rule in a vacuum, but it does seem to me, one, that the statements that were made to the doctors that could potentially impeach or contradict plaintiff's own testimony, that is likely to come in. And 2, if there's a doctor that says she suffered no emotional distress, whether it's garden variety or not, that seems to be relevant. Ron, I guess I'll have to think about it then. The court, all right. The court, the other issue was the witness list, the names on the witness list. Let me pull up the most recent one. So the court already excluded Avila, Anderson. Avila, Your Honor, yes. And to be clear, the most recently filed witness list was by plaintiff's counsel without consulting us. The court, okay. Mr. Anderson, and it's different than what we sent him. The court, all right. So we are going transcript snip by transcript snip, but A, because I do have to take T to an appointment, and B, because they are going to go through each one. Later today, I will put a link to this entire document in the description if you guys want to go grab this. But we've gone through all of these transcript snips in the declaration, and I don't want to run out of time to get to Ron's response. So thank you for understanding in, unfortunately, a little bit of a rare time situation today. But I want to take a look at what they're asking for, and I want to make sure we get to the response. So I will link this later today, and I will send the link out in the Lawnard app, so you guys will have it. But that's going to be after I take T to the doctor, because if you want to go through the rest of the transcripts, they went through and highlighted each section that we just read. So let's look at their motion real quickly, because I want to get to what they're asking for in the OSC. But what they're asking for in the OSC is based on everything that we just saw. And so this is, why are you asking me to sign in again? No. What are we? I just want my documents, please. Can we just open the document? And of course the tech is like, why would we do that? Why would we do that? Oh, give me 2 seconds while the things are thinging. All right. Here is I'm going to really quickly look at what they are asking for, because that motion is 14 pages, but that 14 pages is really a summary of the law mixed with the arguments that we just saw. So those 25 counts are what they are saying. He violated court orders, rules of court, improper argument, and the rest of it. This is the motion regarding that from October 2nd, 2025, application for issuance of an order to show cause, RE Ron's trial misconduct. Application for issuance of order to show cause. Defendant, Cardi B, respectfully applies to the court for issuance of an order directing plaintiff's counsel to show cause why he should not be sanctioned or held in contempt for trial misconduct, including violations of court orders and the California rules of professional responsibility. This application is brought by permission of the court at the trial of this action and pursuant to the code sections listed. The issuance of an order to show cause is appropriate because the record establishes the court observed firsthand Ron's willful disobedience of lawful court orders and improper advocacy, despite the court's express admonitions to him, which willful disobedience and improper advocacy threatened to undermine the integrity of the proceedings. Based on the attached memorandum, the plaintiff was provided notice on September 2nd that Cardi B would apply to the court for the issuance of the foregoing order. And then the table of contents goes through the violations of the motion in limines, the questions, the improper closing arguments, and the sanctions available, which is what we're going to skip to because we went through all of those sections of the transcript before. So I'm going to zoom to the bottom of this document to see what sanctions they are asking for based on all of the things that we just saw. And the allegations of misconduct. So let's put there we go. I'm trying to make sure that the documents are as big as possible so you can read them, which is lovely. The sanctions available to the court. Ron's choice, and again, he is referred to as Mr. Rosen in all of this. I have shortened it to Ron. Ron's choice to disregard the court's orders in limine and argue facts outside the record after the court's express admonition not to do so implicates the court's contempt power. The court may issue an OSC directing Ron to explain, if he can, why he should not be held in contempt under the civil code. I think the court will do that. I think the court will grant an OSC and say, explain yourself. Tell me why. Tell me why. Tell me why I shouldn't hold you in contempt. Tell me why you shouldn't be sanctioned. Explain it to me. I'm waiting. I think the court will grant an OSC and schedule an OSC hearing. The court may issue an OSC directing Ron to explain, if he can, why he should not be held in contempt or otherwise sanctioned under those statutory provisions. Also, but I'm a young lawyer, my reputation? Not going to work. You're right. Chat, you're right. He's exactly going to say, ain't nothing but a mistake. 100%. You guys are so quick. Ain't nothing but a mistake. Tell me why. I know he is. For the love of the Backstreet Boys, Ron, explain yourself. On a finding of contempt, penal sanctions may include fines up to $1,000 per violation. Do you see where this is going? Do you see why they listed them all out separately? Hey, Your Honor. There are 25 instances. Why don't you just sanction him $25,000? When contempt stems from violations of court orders, the court may additionally order fees paid to the party initiating the contempt. Sanction him $25,000, Your Honor, and then give us attorney's fees on top of it. Please. Cardi B identifies at least 25 distinct violations by Ron of the court's orders in limine, order from the bench prohibiting argument of facts not in evidence, which is also just the rules of evidence, and establish principles as to proper and improper closing argument. Ron's misconduct was egregious, persistent, and included both calculated attempts to do end run around the court's orders and unequivocal misrepresentations of the evidence to the jury. Despite multiple sustained objections, warnings, admonitions, he persisted, made no effort to mitigate, and continued the same misconduct through closing. Deterrence is necessary and appropriate. Your Honor, he is a menace. Conclusion. Accordingly, Cardi B respectfully requests the court issue an order directing Ron to show cause why he should not be held in contempt and sanctioned. Ron responded. Oh, no, that's not helpful. Ron responded. J. Michael, this is a great question. Good to see you. Would this be full attorney's fees for the trial or just for sanctions? It would be attorney's fees to deal with the sanctions argument. Ask it differently, Mr. Jackson in the chat said, dude's going to crash out. It's like you know what's going to happen. It's like you know. It's like you can see it coming, right? I see it. Yeah, I can see it coming in. Emily, the ADHD is ADHDing today. Yeah, yesterday still kind of broke my brain. So where does the money go? Leonard JM, if he is sanctioned, the money goes to the state, I believe. I would actually need to double check where civil sanctions go, but the attorney's fees go to the attorneys. So he can be sanctioned as like a punitive sanction, like, hey, lawyer, do you care about money? Right. We're taking that from you. Don't do it again. Stop it. Pay us. And then attorney's fees would go to Cardi B's lawyers. Carmen said, you done fucked up, Aaron. Back to Key and Peele. Oh my God, this last week during fall break, I was working in my office in the evenings and often we'll put on movies or what have you in the background. And I was watching all of the Pitch Perfect movies. It was very fun, which then always leads to watching Key and Peele. All right. This is the October 3rd response from attorney for plaintiff, Amani Ellis, Ron's response. Ron's response is an application for issuance of an order to show cause regarding Mr. Anderson's trial misconduct. To the Honorable Court, Plaintiff Counsel Ron A. Rosen, Janfaza, Esquire, is extremely disappointed that defendant would present an application for issuance of OSC regarding trial misconduct when defendant made it clear that the parties would be walking their separate ways. If you are listening in the background, this is not EDB hyperbole. I am not exaggerating. That is exactly verbatim what that first sentence says. Your Honor, I'm so disappointed. Cheryl said, I see why you had to yell and stop reading. Yep. I went to download it and I was like, wait, he didn't respond. He filed his own application. And then I saw plaintiff's counsel is extremely disappointed. And I was like, shit, no, stop reading. Damn it. Your Honor, he did it. How dare he? How dare he? I'm so disappointed. Defendant made it appear that the parties would be walking their separate ways. In the hallway, maybe they just didn't want their glasses to get damaged. They were concerned. Defendant made these statements on defendant, Cardi B. He's talking about Cardi B. He's talking about Cardi B. Defendant made these statements on September 2nd to all the news stations when she left the Alhambra courthouse. But Your Honor, Cardi B said we would all just be going our separate ways. At the end of trial, they were talking about a sanctions hearing. But Cardi B said to the news she was going to let it go. She wasn't talking about you, counsel. Plaintiff Amani Ellis was wronged by defendant Cardi B on February 24th, 2018. The jury doesn't agree. Defendant obtained a defense verdict and should be happy with the result. Instead, she has decided to file a frivolous application for OSC. Counsel, do you know what the word frivolous means? Because that OSC had a lot of instances of misconduct. Like a lot. Also, she should be happy with it. I can't even. I don't have enough time to address the ridiculousness. Defendant obtained a defense verdict and should be happy with it. A letter was written to defense counsel, Mr. Anderson, on September 3rd, asking for a timely response within 24 hours. Yeah, I wonder what that letter said. Defense counsel completely ignored said letter, making it appear that everything was fine and that the parties would be moving on. They gave you notice on September 2nd. Nothing that happened on September 3rd fucking matters. They gave you notice the day before. They didn't change their mind. Defense counsel, this is Cardi B's lawyer, whose motion we just read. Defense counsel did not meet and confer and waited until the last minute to file the application for OSC on September 2nd, 2025, in the middle of the Jewish high holidays. So on September 3rd, you were aware that they had filed on September 2nd. I'm sorry. That's not your internet. I'm buffering at the next sentence. You were in court on September 2nd when they told you that they were filing. You knew. They didn't wait till the last minute. You were in court. Plaintiff's counsel is not a quote unquote seasoned trial attorney. I am reading from his own motion, y'all. It doesn't matter. You have a law license. You have to adhere to the rules. Also, in 2023, you were crying to the court that you were a young attorney at 47 years old. What year did you become a lawyer? Hold on. I forgot. I know it was close to when I became a lawyer. It new, I mean, is not new. Like, bro, you've been a lawyer for almost 20 years. Let's see. Oh, there it is. I'm just pulling up CalBar real quick. Why is this not coming up under his? Not Ryerson. Rosen. Did I type something wrong? Hold on. I'm going to have to go back through this later. But apparently there are numerous lawyers named Ryerson. Y'all, I have suggestions for your marketing and your SEO. Attorneys, Ryerson. I have thoughts, but I'm going to let it go. I'm going to let it. I have to let it go. Emily, you cannot. We do not have time to derail. We do not have time to derail. Oh, okay. Let's see if I can try one more time on the attorney name search, because I can only imagine that this lawyer has been, and I know I had found it before. Oh, there it is. Oh, good Lord. Admission date, May 2004. I mean, your bar number's lower than mine, but not by much. May 2004. So if you're not a seasoned trial attorney, it's because you're not choosing to do trials. But you've been a member of the bar for over 20 years. Counsel is not a seasoned trial attorney and did not intentionally, Sarah Boone, did not intentionally attempt to violate any court orders. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial, which lasted from August 25th, 2025 to September 2nd, 2025. Plaintiff counsel's law license is the most important thing to him. If you are listening in the background, I am reading this verbatim. Plaintiff counsel's law license is the most important thing to him, which he would never sacrifice for any reason. Plaintiff's counsel previously proceeded to trial in approximately 10 different cases. I mean, I guess you're not going to trial very much, but that's not brand new, sir. I've been to trial in 10 cases. I mean, you're not a seasoned attorney. We've perceived that correctly. Emily, do not get into a pissing contest on how many more. I think I did that many trials in my first 6 months as a DA, but I digress. 10 different cases in his career as an attorney. And in one of them, you managed to get sanctioned at least $20,000 and get a trial mistried for fighting with opposing counsel. I would say it's a storied record at this point, but not in a good way. Plaintiff counsel also served as co-counsel in several cases in his career, so more trials, right? It is clearly apparent, it is clearly apparent that defense counsel intentionally tried to ambush plaintiff's counsel. Defense counsel waited until the Yom Kippur Jewish holidays to file said request. He told you in court on September 2nd when you were both in court. You were in court together on that day. Oh my God. Oh my God. You were in court together. There was no ambush. It's like he's just pulling out a straw from every bucket he can find. Your Honor, I'm inexperienced. Your Honor, my law license means something to me. Your Honor, I'm sorry. Your Honor, but my religion. Your Honor, but the holiday. You were in court on September 2nd. It's clearly apparent to defense counsel, or that defense counsel intentionally tried to ambush plaintiff's counsel and waited until Yom Kippur to file the request. Plaintiff's counsel was not aware of this filing until today, October 3rd. Chat, when was the other one filed? Wasn't it filed October 2nd? So he wasn't aware of it until the next day. What? They gave notice. They did. They gave him notice on September 2nd. He wasn't aware until October 3rd. It was filed October 2nd. When he returned to work after the Yom Kippur holidays. So you knew the next day? You had notice it was coming, and it was filed within 30 days. It was filed on like the 30th day. Plaintiff's counsel respectfully applies to the court for an issuance of an order directing defense counsel, Mr. Anderson, to show cause why he should not be sanctioned or held in contempt for his trial misconduct, including violations of court orders and the California rules of professional responsibility. I know you are. But what am I? We've reached, Your Honor. He did it. Ron goes on to say that Mr. Anderson violated California Rules of Professional Conduct 3.10, threatening criminal, administrative, or disciplinary charges. Defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the court of the trial, that he would report him to the state bar. Your Honor, he said he was going to report me to the bar. You were blatantly violating the motions in limine in front of the jury. Also, notice that there's no transcript. There's no cite. But Your Honor, he's touching me. So with the assertion only that plaintiff's counsel threatened to report him to the state bar, Ron is saying that defense counsel violated the rules of professional responsibility. Ugh. This application is brought by permission of the court. I don't think that's true. I don't think that Ron asked for the court's permission to file a motion for OSC. And I think the court will probably throw this out accordingly and then order him to respond to the other motion. Because I don't think he asked the court for permission. Defense counsel asked for permission at trial and the court said yes. This application is brought by permission. The next paragraph says the issuance of an OSC is appropriate because the record establishes that defense counsel threatened plaintiff's counsel to obtain an advantage in a civil matter both before and during the trial. Lastly, on August 27th in the Alhambra courthouse. What? Defense counsel also physically intervened when plaintiff's counsel was speaking with Dr. Finke on August 27th at the Alhambra courthouse, which amounted to an assault and battery. Sir, what are you talking about? This is not the only time that defense counsel has unlawfully made contact with plaintiff's counsel against his wishes. Oh my. To add insult to injury, he says, on September 2nd, defendant threw a pen at a man outside the Alhambra courthouse. Defendant Cardi B? The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. Sir, in your response to the 25 counts of violating the court order and improper argument, your argument is, nuh-uh, Your Honor, Cardi B threw a pen at a guy. Okay. But Your Honor, Cardi B threw a pen at a guy. He says it caused another individual to get pushed and injured, and it was also completely unlawful and disrespectful. But Your Honor, Cardi B was disrespectful. He said it was disrespectful for the defendant to injure others during the trial at the Alhambra courthouse. On the Alhambra courthouse property, which she did on September 2nd. I'm sorry, September 2nd is verdict day. That's not during the trial. The trial was over. This is not the defendant's first time injuring others. Oh, so you're not answering the charges at all. You're not answering the charges, but Your Honor, Cardi B. But Your Honor, what about her? This is not defendant's first time injuring others, he says. In July 2023, defendant physically threw a microphone at a concert goer at Dry's Beach Club in Las Vegas, Nevada, who was injured. Excuse me, counsel. Wasn't it? Oh, yes, it was. July 2023, when you put your hands on opposing counsel and stomped on his glasses, causing a mistrial in Judge Recana's court? That you? No? Yeah? Okay. Sure. But Your Honor, Cardi B threw a microphone. That has nothing to do with whether you improperly argued at closing arguments or not. The deflection is ridiculous. He goes on to say, defendant, Cardi B, clearly feels she is above the law and can do whatever she wishes to do. Sir, I don't think you're talking about Cardi B. Who feels that they can do whatever they want to do? He goes on to say, plaintiff's counsel is limited in his ability to provide additional information at this time as he is represented by counsel for defense counsel's wrongful conduct. Your Honor, I have a lawyer. Plaintiff's counsel nonetheless submits this application in good faith, so the court is made fully aware of what transpired. Sir, they submitted transcripts and you said, but Your Honor, Cardi B did shit. It's not relevant, counsel. At all. They submitted all the transcripts. Maybe you should have let your lawyer review whatever this is, because this isn't a proper application for an OSC. Maybe you should have let your lawyer do this. Plaintiff's counsel nevertheless submits this application in good faith so that the court is made fully aware of what transpired with Cardi B in Vegas in 2023 or what? This application is based on notice. I'm curious about that. The memorandum of points and authority attached. Declaration. Oh, there's a declaration. All pleadings on file in this action, papers and records. He's just like, include all of it. Let's look at the application, shall we? Or the declaration. In the chat, Lara M said, he said, am I the drama? Correct. It's fully the I'm rubber, you're glue defense. The deflecting is wild. It's what we saw in court, though. What we saw in court was defense counsel say, hey, this, and then him go, Your Honor, they did that, not me. The circular argument, the deflecting. Oh. So he's declaring that he is extremely disappointed. Your Honor, I declare under penalty of perjury that I am disappointed. Lauren, EDB, can you imagine Ron and Lewin in a courtroom together? No, the sheriffs actually have to might keep them from fighting. No. It would not be good. Nope. I don't think that this attorney should be representing criminal defendants. The rights at issue are substantial. But yes, that would be a mess. Agreed. God, I really would love to know what Mark Geragos thinks of this guy. I am so curious. Okay. He's filing an affidavit that he's extremely disappointed that defendant would present an application for issuance of OSC when defendant made it appear that the parties would be walking their separate ways. Defendant made those statements on September 2nd. We watched Cardi B's statements. Cardi B said, I am not going to cross-claim someone who files a frivolous lawsuit against me this time. I'm not going to sue. Cardi B said, I'm not going to sue Amani Ellis, but y'all are on notice next time. Next time, if y'all come at me with bullshit, I'm going to sue you for bringing it, but I'm not doing that now. She said nothing about a motion for sanctions against counsel. She said she's not suing your client. I wrote a letter to defense counsel, Mr. Anderson, timely response within 24 hours. Defense counsel completely ignored said letter, making it appear that everything was fine. He's just repeating what he said. I know. Thanks, T. Completely ignored said letter and making it appear that everything was fine and that the parties would moving on. He said would moving on. Defense counsel did not meet and confer and waited until the last minute to file the OSC. He's literally just putting in his affidavit exactly what he put in his motion and going like Ipsy Dixit. But Your Honor, it's true. I'm saying it's true. I'm not a seasoned trial attorney. And I did not intentionally attempt to violate any court orders. That's not the standard. This is a verbatim recitation of what he said. He also says that he believes defense counsel violated California Rules of Professional Responsibility 3.10 and then attaches them. Because this is not an affidavit and it is just a copy and paste of exactly what he said with no additional detail, I am not going to finish reading this because I do need to take my kiddo to an appointment. Here's what I think we need to do. Because this hearing's on Friday, I wonder if there will be more filings today. We might need to finish this tomorrow. Chat, let me put up a poll real quick because I'm going to have to take T to an appointment. If there are more filings on this today, do you guys want to go over them tomorrow? I'm going to start a poll. If, instead of moving on to a new topic. Because if there are more filings today, all of you are like, I need the resolution. All of you are saying yes. All right, I put up a poll, but all of you are saying yes. Everything in this affidavit is exactly what he said. Also, just calling something an assault is wild. I wonder what Dr. Finke would think of this. Dr. Finke, what were his fingernails like? Were they buffed? Were they polished? I have a question. And then he just attaches the rules of professional conduct like it matters. I want to see what Cardi B's lawyers say. So I think tomorrow we're going to need to part 2 this. So let's summarize what we did today. And then we're going to continue tomorrow because today we got the initial motions. There's got to be a response. And tomorrow's Wednesday. It would make sense that they would file it today or maybe tomorrow. I'll take a look and see what we can find. We're going to have to talk about this a bit more. I feel like if there's no other filings, we'll cover something different. But if there are filings, we'll just cover this. I really hope there is media in the courtroom on Friday. If not, I'm going to have to order the transcripts like 100%. I'll find the court reporter and order the transcripts. I just want to know what's going to happen. Anthony said, is Cardi B paying for the sanction or is this lawyer doing it for free? No, she would be paying for the motions, but they are asking for lawyers' fees and they might get it. Let's do a quick summary. I am sorry I'm not going to be able to get to more questions. I've got to take Kiddo to the doc. We will talk about that later, but I need to take Kiddo to the doc. So apologies on that. Crocker, thank you for the gifted memberships, but we will talk lawyer tea more. Kelly Kell said, I take the MPRE next month. Well, this case is a study on what not to do because this is wild lawyer behavior. So what did we learn today? Well, we went over plaintiff Amani Ellis' attorney's prior incident in a Geragos and Geragos suit, wherein a mistrial was declared because of an attorney altercation in the hallway between plaintiff's lawyer, Ron Rosen, and the attorney for the defendants. The defendants in that case were Geragos and Mark Geragos because it was an attorney malpractice suit. The altercation of the attorneys in the hallway caused a mistrial of a civil lawsuit that had been going on for over 2 weeks. In that same civil lawsuit, attorney Ron Rosen was sanctioned over $22,000 for discovery violations. And now we have seen Cardi B's lawyers file 25 different counts of instances where they are asking for sanctions up to $1,000 per incident. Plus they are asking for lawyers' fees. Plus they're like, hey, Your Honor, you can find him in contempt of court because while they are arguing numerous improper arguments in closing argument, they are also arguing that not only that, but there were multiple blatant violations of the motions in limine. And they listed out what the motion rulings were and then what the lawyer proceeded to do. And we watched those things happen in real time. And at the end of court, they said, we need to bring up the issue of sanctions. And the court said, I will set a sanction hearing. And the sanction hearing is set for October. I almost said August. For October 17th. So is the court going to order Ron Rosen to explain? I think so. Could Cardi B's attorneys win lawyers' fees in this? Yes. Could he be found in contempt? Yes. Could he be sanctioned? Yes. Will this get reported to the state bar? Yes. What will the state bar do? Well, we'll see. The state bar doesn't comment on attorney discipline, and sometimes you will see it on their record, but oftentimes the state bar will deal with it without it ever showing on a lawyer's record. But in the case with the Geragos trial, and in this case, we have seen attorney Ron Rosen respond the same way. No, Your Honor, I didn't. My law license is important to me. And in this one, he actually argued, I'm not a seasoned trial attorney. He was admitted to the Bar of California in 2004. First of all, once you're admitted to the bar, you have to follow the rules. And the court spelled it out numerous times, saying, I didn't know better isn't a defense. He also said that he has counsel, so I wonder if his lawyer will be filing anything ahead of the hearing on Friday. Sanctions will not be issued at that hearing on Friday. It's whether or not this will go forward for him to answer, and it might result in a hearing. Can you imagine if they put him on the stand under oath and literally are like, what were you thinking? But I don't think I've ever seen a lawyer say, Your Honor, I'm not a seasoned lawyer. I'm just a baby. I didn't know. That's not a defense. Oh, and then he said, but Your Honor, the defense, Cardi B's lawyers, threatened to report me to the state bar. They should be sanctioned. Oh, and Cardi B, Your Honor, she's rude. He actually brought up in his motion that Cardi B threw a pen after trial and threw a microphone in 2023, he says. So instead of addressing the allegations against him and what opposing counsel said, he went back to attack Cardi B again. So what's going to happen from here? Well, let's see if there's more filings. And if there are, we will absolutely be covering those filings. I can't wrap up if you're staring at me. I'm wrapping up. Okay. So, what will we see from these sanctions? Will Cardi B's lawyers get attorney's fees? What will the answers be? Also, yes, Dr. B is just like, the ADHD, you must go. I must go. But this is some of the wildest shit. We've got a full-on time bouncer here. We need it. But this is some of the wildest shit. And it's the stuff we don't always see covered because the trial is done, the verdict is in, but the litigation isn't over. And when I say litigation doesn't end when the trial is done, this is what I mean. This is far from done. I think the court's going to set no SC. I think the court is going to require the attorney to answer for the violations of the court orders and for the improper argument in closing. I think the violations of the motions in limine are the more serious, though there were some pretty egregious things in closing. If it was just one, I don't think the court would take it the same as the fact that there were more than 18 sustained objections. That is a pattern. It's not a, oh shit, I shouldn't have said that. Apologies, Your Honor. That happens in court. This was persistent and consistent. So we're going to have to see if this attorney is a menace in the courtroom and in the hallways. Law nerds, you are the best. I am sorry that I have to scoot. I am going to make these filings available to you after T's appointments. Thank you all for the well wishes. Apologies that sometimes stream life and mom life collides. Y'all know what it is. I will see you tomorrow. If there are more filings, I will let you know in the Law Nerd app today, and we will cover them tomorrow. If there aren't, we will pick a different topic. Either way, Law Nerds, I will see you here tomorrow. Same time, around 11 a.m.-ish. So I will see you soon. You guys are the best. Let's roll the outro. And don't forget to check out today's sponsor, June's Journey. Law Nerds, you're the best. I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.